Abusia ini komo awo channel so aha AGH Politics Avenue podcast or set trend because make headlines na jembre na EDB exomo ani dim ene ya block simu onia yembo enra aye political highways nim ejadema enye asem koto akra no onia ye ko aye yensem a aye lawyer Frank Davis woye legal practitioner wo Ghana hasia ono ene ye Ken Ofori Ata ni lawyer na okupiem ewo eye hot issues so na papa nitimi ebowura eye criminal justice system ewo Ghana hasi na wo che na dwen efa kwanya ye befa so a na aban no efa so a ye criminal justice no system no mo betimi aye flexible aboa menu mienu nyina na se da chimbia no se yekoto aban amani mu a se enkoye se mpo bail condition crampo no na akoye etwamene bo onua papa no ebibi no mo so bebre yemongura na so
to run a law school. You see, so if we are going to get all manner of, I just don't want to go into mentioning of tertiary institutions which are running
but
law
why
programs.
don't you trust that those institutions can also train well?
I'm not saying they cannot train well. I'm saying we have the requisite number of personnel, legal professionals, so to speak, to undertake this program.
You don't think we do?
Your guess should be as good as mine.
I see. But there will be the national bar exam, which will be overseen by a regulatory authority, so to speak.
And the Ghana School of Law exams is not overseen by a regulatory authority.
I'm not doing a comparison.
But we have to start the comparison. We have to start the comparison if that is where we are going.
If that is what we are saying.
If there's going to be a national bar exams and people are going to supervise, is there not going to be a cabal? The cabal that you were talking about?
The perception of a cabal.
Is there not going to be one? I mean, so what have we cured? Are we cutting our noses to spite our faces? I mean, it's a chicken and egg situation. You just don't do anything because you want to do it. Let's look at the far-reaching.
So what we have done, based on what you're telling us, is that we have decentralized the problem and not dealt with the actual problem.
You have put the words in my mouth.
I see. So if there was anything you would have loved to see, I mean, we've gone past whether or not we can make changes to the legal education reform, but perhaps administratively we may be able to do things. If there was something you'd like us to do now for legal education in the country, what would it be?
Let us strengthen the institutions we have presently. If the Ghana School of Law is not accommodative enough in terms of numbers, infrastructure capacity is needed. We can move Ghana School of Law from its present location and put up a much more bigger facility to hold the so-called deficit in the number of lawyer-client relationship in the country.
I see. Let's talk about the criminal justice system as we move away from legal education reforms. And like you said, we'll see how it plays out when it's finally operationalized.
The sweetness of the pudding is always in the eating.
Absolutely. The growing perception that justice in this country is slow, is technical, and unevenly applied. Is that a fair description of what the criminal justice system is in the country?
It certainly is not. You see, crime is different from civil responsibilities and obligations. Because crime carries onerous consequences. You stand the peril of being in prison. So our criminal justice system is fashioned out on the premise that the accused person is presumed innocent until he or she is proven guilty beyond all reasonable doubts. any shadow, the minuscule shadow of death, of doubt, inures to the benefit of the accused person. What does that mean? You have to take the accused person through due process and make sure that all the avenues available to the accused person is exhausted. Because he or she stands on the threshold of criminal conviction. So his liberties will not have to be abused. At every stage of the system, his or her rights should be respected. So the criminal justice system grinds slowly, but eventually it gets to its final
Well, some think it's grinding a little too slow, particularly in certain high-profile cases.
Are we talking about particular cases? Are you talking about particular cases, or are you talking about the criminal justice system in a whole?
The criminal justice system as a whole. There are those who think that it grinds a little too slowly. It does not apply evenly. And in high-profile cases, politically exposed people are able to delay the case a lot with all kinds of legal challenges and maneuverings.
You see, when you are not confronted with a legal matter, you think that lawyers are technical, Kemeni, but I don't wish one for you. But if you have a legal problem, maybe you'll be kind enough to engage me. And when you do, and I start rolling out the legal remedies available to you, you know that lawyers are not too technical after all. You see, because if I have to do a good job for you, I have to make sure that everything in the books is exhausted. So if I'm going through that process, I do not understand why anybody should say that lawyers are being overly technical.
Are those legitimate safeguards, or they are just tools of evasion?
Oh, maybe, okay. Let's say 98 out of 100% cases are legitimate. Other lawyers with great respect maybe maneuver the system a bit. But in all, if I have to do good work for my client, I should make sure that every legal remedy I can fashion out is brought to bear on the case. At the end of the day, if we should lose, my client will not say that I didn't do a good job. You see, and the law allows us at every stage of the proceeding to confront issues with the superior court, which is higher than the court of first instance. So if a matter starts in the high court, there's a ruling, I'm dissatisfied with the ruling, obviously move to the court of appeal. And if I'm still dissatisfied, I move to the Supreme Court. These are remedies which are available in the law books. I mean, it is not something which is fashioned out of a vacuum. It's something that we came to meet, and that is what we will explore. So,
which means that there's a thin line between the wheel of justice grinding slowly and then the use of remedies to delay cases.
You see, I wouldn't say delay in itself of delaying. See, if I have to appeal against a ruling in a high-profile criminal matter, like you say, and the generality of Ghanaians are complaining, it means I should leave the fate of my client to the whims and caprices of maybe others who don't understand the legal system. I think that position will be challenging. That position will be challenging because due process is due process. I mean, and in every other profession, there are ways and means of challenging what is wrong and what is not too good. If you go and see a medical practitioner and you are given prescriptions to start with, and the prescription does not work,
right?
Medication does not work. Eventually, maybe if you have to go through the process of surgery, would you say your medical rights are being prolonged or delayed. So if we should say that about lawyers, we are not being fair. I think that gradually Ghanaians should begin to understand that it is not as if we just do it out of nothing and we just want to prolong, but we have due process to follow, and when it means we should follow, we follow them.
Well, so when we flip the page on politically exposed people and the cases or corruption-related cases, and we look at the criminal justice system at large, one of the things that we had a very big challenge with is the remand system. Has that improved over the years?
There was, once upon a time, we started what we could call the Justice for All system.
The Justice for All program?
Where the Justice for All program, where lawyers were recruited to go to the prisons and engage people who had been in remand for an unreasonably long period of time, bring their cases to the courts, and some of them eventually secure their freedom. You see, there is something which is playing out, and if we don't confront it, it will hang around our necks with these onerous conditions of bail, which the likes of NIB, now BNI, Yoko, and others have started doing. You see, bail is a fundamental right. In the olden days, I mean, the antiquity of our legal system, bail was known as suffering an accused person to be at large. You suffer the person to be at large. You grant the person his liberties and freedom. And it's not supposed to be used as a tool of vindictive prosecution. So then a person of interest, a suspect, who is not even yet an accused person, goes to a prosecutorial institution and bail is set at 5 billion Ghana cedis with 5 sureties to be justified, landed property. Are you convicting the person before the person has his or her say in court? Because you see, a person of interest, a suspect, is not an accused person. At the end of the day, IOCO, NIB, BNI, whatever, you will have to arraign the accused person before court. And when you arraign the accused person before court, the bail conditions set by the court might be far, far, far lower than what IOCO and BNI said. So what is the justification for it? What at all is the justification? Is it to punish the people? And we look on gradually.
Why would you see that as punishment?
It is punishment.
Why so?
No, it is punishment.
Perhaps it is vis-a-vis the crime or the alleged crime.
Look, the only thing that an accused person or a person of suspect needs to do is to provide sureties. Because at the threshold, the person is not guilty. So why impose such onerous conditions of bail? Because what, you want to punish the person? The person will have to go to court. And you will have to prove the guilt. At the outset, just because the person has been arrested or the person has been invited to answer to questions and the person comes, then you want to curtail his liberties. Keep him there for an unreasonably long period of time because you have set bail at 5 million. And then you setting the bail at 5 million. Do you have property worth 5 billion? Those who set the conditions, do they have properties worth 5 billion? So that when you say I should bring sureties 5 billion, where am I going to get them?
No, but that's a lot of there's a lot of discretion in bail, right?
The discretion should be exercised judiciously, not capriciously.
The capricious part is how I'm failing to see.
You see, when an accused person or a person of interest or a suspect say, oh, he has stolen 500 million Ghana cedis, 10 billion Ghana cedis. Have you proven it?
Not yet, not at the time.
Yes, so why set bail? Because the person is supposed to have embezzled or misappropriated 500 million.
So what should we do then?
Reasonable conditions of bail.
Who is determining that reasonability?
Let the court do it.
Okay.
Let the court do it.
But our framework at this time also gives the police, IOCO, and BNI also the ability to grant bail.
They should grant police inquiry bail.
Okay.
Or investigative proceedings bail.
Right.
Bail is the preserve, the final authority on whether the accused person should be made to answer for his charges.
Which is why I'm asking.
Yes.
Outside of the court, if you get a court one, you say it's likely that the court will reason around it, and it may not be as high as those agency-related bills.
Yes.
Right. So, but at the agency level, the reasonability is on the agency to decide that this is good bail for you.
And I'm saying that discretion, Kemini, is being abused for political expediency.
Oh, really? In this country?
Yes.
How many of such have happened?
Oh, Kemini, stop this. We all be in this country. We are all here. We all be in this country. People go and, they will unreasonable, and even when somebody comes to sureties, wait, come and see us tomorrow, come and see us the day after.
But which is why there is also the room for you to go to court if you think the bill is not reasonable.
You see, the interval or space between when you are kept in a facility and going to the court for, you can't go to the court straight away for bail. Maybe you have to use other processes of habeas corpus. The authority will have to produce the body of the accused person. So, between the period of exhausting those procedures and when the person is in the detention facility or investigative institution facility, also has to be reckoned against criminal requirements that an accused person of interest or a suspect should be granted bail within 48 hours. If after the 48 hours, bail is unsatisfied, you have to arraign the accused person before court. But what do we see? Most of these institutions abuse that process. Somebody will be kept for more than 2 weeks because the person has not been able to meet the bail conditions. It is not the preserve of those institutions. It is not their preserve.
How do we cure that?
It is the preserve of the court system.
How do we cure the level where the agency is able to grant bail and grant what you have called unreasonable bail?
Maybe there are practitioners who are considering bringing a writ in the Supreme Court to have that matter determined.
Not you.
When we get to that point.
When we get to that point. But overall, we've talked about the role lawyers will play in the criminal justice system. But the criminal justice system is also much more than that. It starts from the police and all these investigative agencies, the judiciary itself. How would you describe the evolution so far?
Nothing so drastic has changed. The enabling problems are when, let us speak in truth. Enabling problems are when we set up institutions as political bodies, and the idea is maybe to create the impression that some people have looted state coffers, and political parties make all kinds of promises to their supporters and to the country that people have stolen monies from the state, so we'll have to recoup or get them to account for their stewardship in state offices and governmental positions. So we create a semblance that there's a massive loot. So then when the reins of government change, the ruling government tries to maybe appease its supporters. So all manner of charges are leveled, and then people are thrown into custody and they are squeezed. I honestly, as a trained lawyer, do not see any benefit that does to our criminal justice system.
Why
The
so?
Constitution is the prevailing law of the land. And we all have to abide the dictates of the Constitution. Anything outside the remit of the Constitution is bad.
And going after people who allegedly have caused, who allegedly have been involved in corruption or corruption-related incidents is against the Constitution.
I'm not saying so. I like your choice of words. Allegedly. Allegedly. Maybe. Not that the person has committed a crime. Allegedly. So before the proven crime, let's stick with allegedly. So if it's an alleged crime, why don't you wait for the person to be convicted by a court of competent jurisdiction rather than pander to the court of public opinion?
Well, you see, I'm trying to understand exactly what you're talking about. That because if the person is politically exposed, most likely already is in the public, it becomes a high-profile case, the public will be interested. And so if the government of the day decides that we want to investigate this person for A, B, and C, why should that cause a problem?
Yeah, I'm not saying it's a problem, Kevin. Maybe I'm honest. I'm not saying it is a problem.
Okay.
I'm saying what we do to eventually get the person to face the charges in court is where I have the problem.
What do we do? What have you seen being done?
Oh, when people are denied bail unnecessarily, they are taken through all kinds of processes which do not augur well for their personal liberties and comfort. I mean, that by itself is not something that the Constitution provides for. It frowns upon it. Let us have their rights respected before they have their say in court.
Let's talk about one such case that you are involved in.
Yes.
The case against the former finance minister, Ken Oforiatta, after the break. We'll be right back. Don't go away.
We ain't some who wrote him course watching so I'm now so Jim, that's an so bad in the Dumbi Edumiania. Unia, the best Asia.